Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the laws of Rajiv S. Khanna PC. Today is December 18th. We will be doing these calls every other Thursday, as we always do. Thank you all for participating. Let me get started with the questions that have been posted. The first question is from Sridhara Kunjeti. So, he's currently working with a company that is non-cap exempt. Non-cap exempt, so means normal company. Okay. Employment is ending on Jan 15th. Now he's got a job from a university which is cap exempt, and they have filed a new petition. That start date will be 20th December 2015. Can I work for both places? No, you cannot, because in my view, as far as I know, for working at two places at the same time, you need concurrent H1 permission. So when you file the second H1, you would have to indicate on that H1 this is a concurrent H1. If it is not, I do not believe you can work in both places. Although I must confess, I am not aware of any USCIS comments saying yay or nay definitively on this issue. When we run into this issue, we always advise people not to work in both places. Okay. Your second question was, I've earned a PhD degree from a university in USA. Their green card, does it give you any advantage in the green card? The answer is no. If the bill that was passed by the Senate had become law, that would have helped. But that bill never became law, so people with PhDs from the United States have no particular advantage in getting a green card unless they qualify under EB1 category, which is outstanding researcher or professor or extraordinary ability alien. But for that, your degree could be from anywhere. Okay, so US degrees currently do not give you any advantage in green card. Anupam Sharma says, working for an Indian IT company and they're planning to process H1 or L1 for me. My son is a special child with cerebral palsy and he needs constant support. Now, will this be an issue in getting an H4 visa or L2 visa, dependent visa for him? The answer is no, it should not be, because really United States is concerned primarily with diseases of community or public significance, where, for instance, somebody has a communicable disease like TB, or somebody has a disease that can cause them to do harm to other people. Only those diseases become issues. But a problem like a cerebral palsy, which is a personal issue, should not be a problem for getting a derivative visa. Okay. Also for green card, Sharmaji, I don't think this should be a problem. At some point, officers could ask you, although there is no law that says that they can or cannot, they could ask you, what are you going to do for the child's medical treatment? Do you have medical insurance? But that really is a question beyond the scope of their inquiry. And usually that should not be, like you put it, a showstopper. So don't worry. I think that's going to be fine. I don't see it as an issue. P1S wants to know, how long does B2 visa processing take after I apply to get an approval while in USA, because F1 is expiring without leaving the country? Question is a little difficult to understand, but I think what you're saying is this. You are on F1 and that's expiring and you are applying for a B2. Well, first of all, when you apply for another status while you are still in the old status, even after the old status expires, you can continue to stay in USA while the new status is pending. So if the B2 application takes 6 months or 5 months or 4 months, it shouldn't be a problem as long as you file it before you run out of your H1. Okay, how long does it take? Typically 3 to 6 months, a few weeks here or there, difficult to predict. These times are actually available online. You can take a look at them. They are on USCIS website. You can also reach to them through our website under status check and processing times. We have a heading both in our footer as well as in Just look in the footer. That'll be the easiest thing to do on immigration.com. Next question, M. Ray, he's on H1B or she's on H1B, ready to file 485 in EB2. When they were a student in 2009, they worked illegally. 5 months, got paid in cash. Now the question is, because 245K protects them, but they can't really prove that they only worked for 5 months. Well, first of all, if any time after 2009 you have actually gone outside USA and come back, how long you worked illegally becomes irrelevant. Even if you worked 10 months or even 2 years illegally, but then you left USA and came back, 245K wipes clean the record from before. As long as you've not made any misrepresentations to the USCIS, you should be okay. So 245K works like that. Now, if you have not traveled, I would let your lawyers figure out what is the best way to prove this work. I think an affidavit from you should do it. That's what I believe. Sridhara apparently had a follow-up question. Can my wife work on H4? And the answer is, right now, there is no provision for it. That regulation is still pending. The derivative spouses of H1B holders cannot work right now. But if the regulation gets approved, we were hoping it gets approved in December, within December. There's still 12 days of December left, 13 days of December left. So if that regulation gets approved, then of course people who are in the I-140 approved stage, their spouses will be able to work on H4. This question, GC Seeker 12345, I have marked it as a frequently asked question. So what I'm going to do is I will answer this question, and then I'll invite any discussion on this question. Normally we answer all questions and then open the floor to questions from the community who's logged in. But for this case, because it is a frequently asked question, I will invite questions from you or comments from you on this issue, nothing else, no new issues, after I'm done answering this question. So here's the situation. They used to work for an employer who filed EB3 I-140. I-140 was approved, filed 485 when the dates became current. Okay, then company A was acquired by company B, and company B took over all the immigration proceedings. After that, joined a direct client, company C, got the H1B approval beyond 6 years using company A's I-140, AC-21 document sent. So company C does not file labor or I-140. So they're not going to do green cards. After more than 7 years, somebody who had gotten their I-140 approval from company A, the company that you used to work with, has been given a revocation notice, and there was some fraud being alleged, and everything was denied, and he did leave the United States. Okay. So what are my options if something like this occurs? He's been reading the case Kurapati versus USCIS. Kurapati does not actually stand for this. Let me explain to you what happens. First of all, I-140 can be revoked by the USCIS for fraud at any time. In addition, they can also revoke an I-140 where it was not approvable when filed. So if it was mistakenly approved, it can also be revoked. If it does get revoked, unfortunately, USCIS reading of the law is it gives you no portability right. It gives you no right to priority date. I think that's a little questionable, that part, because if they revoke an I-140 after they have approved it, I can still argue for priority date if the revocation was not for a fraud. Although I think I would probably lose that argument. So in any case, right now, the rule is, or at least the policy is, that if they revoke a case either for fraud or for not having been approvable when filed, you get nothing out of it. Okay, you can't get the priority date, you can't get anything. The problem is, what do? Can you file an appeal, and while the appeal is pending, keep getting H1 extensions? And the answer is doubtful, unless the old employer wants to file the appeal. About 5 years ago, we had a series of cases like this where a company went under, a couple of hundred employees were put on the street. We were able to file appeals on behalf of the employees using the Kurapati logic. What is the Kurapati logic? That's the case in which 11th Circuit this year decided that even employees should be allowed, at least it's a legal issue that needs to be examined, that do employees have the right to fight an I-140 revocation. So in our view, we always took the position that especially where AC-21 rights are involved, employees have a clear actionable claim to the I-140. So it's not only the employer, but even the employee who should be allowed to file the appeal. What can you do? Okay, in my view, the best thing to do is leave this employer and find another employer who is willing to start your green card process. Because if this green card can go away, really you need to have a backup plan. That is the only thing I can recommend. Okay, folks, anybody has any question on this issue, press *5 on your telephone. Any question, comment, anything you want me to address only on this issue. No new questions, please. Nothing new. If you are going to ask me a new question, please put your hand down by pressing *5 again, because we're not doing new questions right now. I have 3 people with raised hands. All right, let's get started. Let me go to the first person who logged in. I'm going in the order you logged in. Richmond, Virginia, go ahead, please.
Hi, Rajiv. I'm the person who has posted this question.
Yes, sir.
My question is with this case, can AC-21 be applied? Because I work for company A for 6 months after filing 485.
Okay, let me first, your question is, can I do AC-21? My first comment is, there is actually no requirement that you must work for a company for 6 months or 180 days to be more precise before you become eligible for AC-21 rights. AC-21 is available when 180 days have passed. It doesn't matter where you were at that point of time. So leaving that aside, is portability possible? And the answer is, as long as USCIS does not revoke the I-140 for fraud or on the grounds that it should not have been approved, it was mistakenly approved. If those 2 grounds apply, then USCIS takes away the right to portability. And courts so far have been agreeing with USCIS that if a case if I-140 is revoked for fraud or mistaken approval, there is no AC-21 portability right. Okay. Anything else?
Yes, I got it. Thank you.
You're welcome. Okay. Let me get on to the next person who got a raised hand. And this one is from Chicago, Illinois. Go ahead, please, Chicago.
Hi, Rajiv. This is Hassan. Thanks for this community service. My question is regarding this FAQ question is, can anybody means if something happened to this status, then can anybody change to F1?
Okay. The answer, the question is, if my I-140 gets revoked, can I change to F1,
right,
a student visa? And the answer is, it depends. If you were on H1 status, first of all, let's say you've got H1 approval for 3 years, even after 6 years of H1 were over because your I-140 had been approved. First of all, chances are the H1 that they have already given you, they probably will not take away. Theoretically, they can come after it, but normally they don't. Okay, if you are on H1 status, you're fine. But what if you are on 485 pending? You don't have any other status. When you have 485 pending, you are not considered to be in full status. You are considered to be in authorized period of stay. In order for you to convert to any status, you will have to step outside USA and come back. So can you take F1? Yes,
Okay.
but you would have to step outside USA and come back.
Okay.
All right?
Sure. Thank you so much. And because I'm sure that some people are getting, a green card with the same company, company A. So I'm not sure. Only a few people are also having this issue. So do you think that the company is fraud or just I-140 is fraud?
Look, it is not necessarily the company's fraud. Sometimes what happens is, and I'm dealing with cases like this, we just responded to 19 I-140 revocations or notice of intent to revoke from one company, simply because this is so ridiculous. And we do charge money, a lot of money for dealing with these cases because it's a lot of work.
Okay.
What happened in this case was, this company was in between moving. So they moved from one place to another place within the same area, within a few miles,
Okay.
because they had bought the
Okay.
whole building. This is a fairly big company. They had bought the whole building, but the signs were not up yet. They were still moving in. Okay. So USCIS
Okay.
conducted a site visit and said, well, this company doesn't exist. Okay. And
Okay.
this is a company with several hundred employees. It's absolutely, there's no question that they exist. So they do sometimes very silly things. Now,
Okay.
in your case, I really don't know whether I would like to take a look at one of the revocations to see what the grounds are. If we can find one revocation and take a look at it, it will give us a very good idea of why the cases are being denied. And that way, we can have some assurance about where the future of the other employees is.
Okay.
So try to get a hold of at least one revocation or notice of intent to revoke. That will give you a very good idea of why these cases are being revoked. Sometimes it's a degree issue. Somebody had a BCom degree, 3-year
Okay.
degree, USCIS didn't catch it, approved the case, and then realized, oh, wait a minute, we made a mistake. And they do this all the time. I've seen cases getting denied and revoked at the I-485 interview stage because they found an error. Okay.
Okay.
Sometimes it could be an ability to pay wage calculation issue. Company didn't have the ability to pay wages. So it all depends.
Yeah, but regarding the ability to pay, if somebody has had an AC-21 and then moved to the different company, so still they will ask the AC ability to pay to the company which has filed a green card for you?
They can, because they want to know, when we approved the case, did you have the ability to pay wages?
At the time.
At
not
that
the
time,
present,
not after that.
time.
Once you've moved out, they don't care. And here is the interesting part.
Okay.
Here is the interesting part. If the company did 21 green cards and 18 people were already getting paid more than they should be paid under their green card, but 3 people were getting paid less and the company is showing losses, you could have a situation where 18 cases are clearly approved, no problem at all, even though company is showing losses. These guys are getting paid more than they're supposed to be getting. But 3 people could be revoked because they don't meet the ability to pay standard.
Okay.
Okay. So that's how it works.
And any merger, if company A merged to company B, so is there any problem rises to the consultant?
Not if the AC-21 decision has AC-21 time has already matured. What happens to the company after that, we don't care.
Okay.
All right.
All right, Rajiv. Thank you so much. Appreciated your help on this.
You're welcome. Good luck. Okay. And there is one more call on this issue. And this is from Richmond, Virginia as well. Go ahead, please, sir. Or ma'am.
Hello?
Yes, sir.
Yeah, I already got my answer.
Oh, good. All righty.
Okay. Thank you.
You are very welcome. Let's go on to our next posted question. But this is a very odd situation, this I-140 revocation. In fact, there's a ruling from a Seattle federal court where the judge very soundly criticized this practice of USCIS of revoking cases 4, 5, 6 years down the line. Sometimes we can't get the evidence that they want because it's so late. But unfortunately, USCIS can at times get away with some great deal of unfairness. Next question is Sona Malay. I just got a letter. This by the way, this question is not very clear. I'm not sure what kind of green card we are talking about. I just got a letter stating that I've been denied at my first interview. I'm assuming that's a green card interview. Me and my wife moved to Texas. Does it affect if we change our address from Virginia to Texas? If it's a family-based case, Virginia will have two choices. Either they can move the whole case to Texas, or because if they're advanced enough, they probably could adjudicate the case locally. Okay. Oh yeah, you have applied through your wife, so it's a family-based case. I would just file my AR11 change of address, and I would call USCIS customer service and let them know that you've moved. Also send a letter to the district, to the local sub office in Virginia to tell them that you've moved. Let them decide what they want to do. What is better for green card, asylum or wife? Well, look, I don't do political asylum cases, but all things considered, if you're getting married to a US citizen or you are married to a US citizen, I think that would be a lot easier. What is the difference in the process between asylum and H-1B green card process? I don't know much about asylum, but the green card process through employment is its own process. It requires permanent employment. It requires going through certain hoops. It requires an employer who's willing to pay for it. So those are the things that we've got to watch out for in the H-1B based green card process. I guess what we mean is the PERM process. But what happens to the asylum process? No clue. You're going to have to talk to a lawyer who does asylums. Personally, I think if you have a clear-cut case for asylum, you should definitely explore it, but try not to change out of H-1B or lose your H-1B, because that way you have both options open. I don't see any problem in applying for a green card through more than one categories. Okay, but check with an asylum lawyer. I really am no expert in political asylums. Preet 131131 says, I'm a US citizen applying for parents I-130. Question is, can they come while the I-130 is pending? And the answer is, it is completely up to the port of entry. CBP at the port of entry can decline to let them enter, but it would have to be somebody really mean. I mean, here are government employee retired parents. I'm sure they're not very young either, and they've traveled 18-20 hours, and you're going to send them back at the airport. It's unlikely, but certainly it is possible, and it is at the discretion of the CBP at the airport. Okay. Can they bring any helpful documents? I don't think they can do much unless they have some ties with the home country, India, where it's clear that they just cannot leave. I mean, I can't think of anything. Petro says, I'm on H-1B, spouse is on H-4, good till 2015, green card filed in EB-3. So the question is, if I return, I mean, he's filed his 485 but couldn't file hers because she was out of the country. So he's coming back. If he enters on H-1, does her H-4 get destroyed? And I don't think there's a clear answer to this question. However, in my opinion, if you look at the memorandum, what is that memorandum? Trying to remember the name. It's just slipping my memory for a second. I think it's back from 2004. There's a memorandum from USCIS that actually said that even if you come back on advance parole, you are working for the same employer, we consider you to be in H-1 as far as getting extensions, etc. are concerned. I think your wife will be on H-4. I certainly cannot swear to it, but in my view, that is not an issue. And we've had clients in this situation before. So please double check with your own lawyers. I'm still trying to remember the name of the guy who wrote that memorandum. You can take a look at that memo also. Down. It slipped my mind. So I personally think she will still be on H4. Okay. NB Raval is I-130 approved. Parents are naturalized citizens. Two kids are citizens by birth. Any advantage of immigration reform? First of all, there is no reform so far. And the president's action does not seem to contain anything specifically applicable to you. So no, I don't see any particular advantage for people in your situation. Sandra Paschal says, I've been a diplomat for 13 years. I want to apply for a change of status under Section 13 and get my green card as well as my family's. I'm still working at the consulate. Sandra, if I remember correctly, under Section 13, and this is just from memory, I'm trying to remember what Section 13 says. I think Section 13 of INA says, first of all, you've got to be a diplomat engaged mostly in diplomatic or quasi-diplomatic activities. You can't be clerical or admin. Second, and so A1, even A2 could qualify as long as they're doing quasi-diplomatic duties. Second, they have to be actually out of status. If you lose status, then you can take recourse to Section 13, if I remember correctly. Third is there has to be some element of hardship. Fourth, some element of national interest. And then only you can take benefit of Section 13. So do research it very carefully. But your question is, do I have to quit my job to apply for residency? And the answer is, again, I'm relying on memory. For people who work at the World Bank, IMF, as well as diplomats, they are enjoying certain privileges and immunities. You have to surrender those at the time you file I-485. Okay. So, and you also need I-566. And I think I-566 is only given once you resign. So double check, but I believe at some point, not right away, but at some point you would have to resign. Next question is Samir. Wife is an LPR, now US citizen. I-130 is approved. Upgrading petition. Question is, she doesn't work, so who do I get 864 affidavit of support from? You know, anybody who is a US green card holder or citizen can sign an 864. Your wife also has to file it even if she has no money. And you need somebody who's got a tax return history. I think it could be possible with just a job letter, but I think you're better off with a person who's already paying taxes. I would have to look at the law very carefully, Samir, but just off the top of my head, making an educated guess, I would go with the friend who's on H1. Well, H1B visa per person cannot be a sponsor. It's got to be a green card holder or a US citizen. Okay. So I prefer somebody who's got a W-2. Next question, reply for me. So here is a US citizen whose mother is getting her green card. Brother is unmarried, 21 years, 7-month-old. There is no CSPA protection here that I know of, Prem, because your application is for your mother. And when your mother applies for him after she gets her green card, he would already be over 21, so CSPA does not apply. Can he come? Well, you can certainly try a student visa. You can even try a tourist visa if there is something physically wrong and he needs to be taken care of. The F4 category priority date, can it be moved to F2B? I don't think so. I don't think so. As far as I know, see, immigration law can be full of surprises. Personally, I don't think so. I don't think you can move priority dates like that. But please, by all means, follow it up, Prem. Check it out. Talk to USCIS. Get a formal opinion. Even if the lawyers have to do some research, get that done. I don't think the priority date can be transferred like that. Do we need same petitioner to transfer priority dates? I just don't think it can be transferred like that. All right. Next question is AKS 341. Working on H1B, I-140 approved recently. 6 years completing Jan 2015. Thinking of changing my job before I lose it. My understanding is if my employer revokes the I-140, I cannot get an extension of H1B. That is correct. Well, the good news is once the H1B petition is approved, and then the last employer revokes your I-140, there should be no effect on your H1 that's already given, and you start a second green card through the new employer, and that should protect your status. So I think you got it. I don't know if I missed something. Change my job with after I leave my current employer revokes the I-140. Okay, yeah, I think I covered all your questions. Next one is also AKS 341. The problem is fiance is Nepal born in a small village. There is no record of birth. She lives in India. They're trying to get the passport, Indian passport, to reflect her country of birth. It's proving very challenging. So he's getting a certificate of non-availability of her birth from her municipality and 2 affidavits from family members who now live at different places in Nepal and India. Can affidavits come from uncle living in India or Germany? Sure. They should be coming from relatives because they have reason to know where she was born. So I don't have any problem with the affidavits coming from relatives. What is the chance of approval if we are able to prove this point 1 and point 2? And the answer is really up to USCIS. I would not care to make a prediction. It all depends upon how tough they want to be. I personally think these cases are always challenging because you are trying to use cross-chargeability and you are claiming that your spouse was born in a place other than the high traffic state like India. You want to prove that she was born in Nepal. It definitely will take some scrutiny because USCIS wants to make sure that there is no fraud or misrepresentation. I don't know what the chances are, but you gotta try. Will they reject my application completely? Well, the thing is, if they reject, you can refile it. If this is the reason, that's not a problem. That case can be reproven, refiled. Do they actually talk to the people who submit affidavits? No, not normally, but USCIS can investigate. I have not known them to, not in these circumstances, but they definitely can. Normally they don't. Next question is Shreyas. Shreyas says, working for a company, by the way, thank you for the nice words, Shreyas, we appreciate it. Working for a company XYZ, they own another company ABC, green card was done through ABC as a future employment. I-140 is approved. I have never worked for this company ABC. Now he wants to go to a company, totally different company. Can I port my priority date? And the answer is yes. You can port your priority date even though it was done as a future employment. No problem. And there is no timeline for it. You can do it anytime you like. Does the old I-140 need to be active? In other words, do I have to join the employer? The answer is no. Would my employer get to know if I file G639? I don't see how they would. USCIS does not share with the employer the fact that you have applied for Privacy Act, Freedom of Information Act request, which is G639. So no, I don't think they should. All right, folks, let's start answering questions. Let's begin with first any follow-up questions. No new questions, only follow-up questions on what I have discussed so far. So please don't ask me any new questions right now. only follow-up questions. Once I'm done with the follow-up questions, then we'll start with the new questions. Press *5 for follow-up questions. *5. And I will call upon you based upon the time you called into the call, the conference call. 2 people have questions. 3 people have follow-up questions. Okay. Once again, I remind you, only follow-up questions, nothing new. Oregon, please go ahead. Oregon.
Hi, Rajiv. This is P1S. I have a question regarding the B2 process. The follow-up is I completed my master's degree and my F1 status expires very soon and this weekend, and I have applied for B2. I want to get another F1 and receive an I-20, but I have not yet received by enrolling in another master's program. I've not got another I-20 yet. So I want to know what my status would be in this period. And by filing for a B2 visa and applying for an F1, a new F1 visa by enrolling in another university, will that be advisable?
Okay. Well, first of all, as long as you have filed for a B status while you were still maintaining F1 status, you are considered to be in something called authorized period of stay, kind of the same as 485 pending in terms of rights and liabilities. So you are in authorized period of stay and you cannot convert from authorized period of stay to another status. You can convert from one status to another status, but not from authorized period of stay to another status. So in order for you to get back onto F1, one of the 2 things would have to be satisfied. Either your break is allowed under the F1 regulations and the second school is just able to roll your service number over to themselves, then the B visa can be withdrawn, B status can be withdrawn, it's not needed. The second situation would be you get the admission, they give you the I-20. Now you have 2 choices. Either you wait until B is approved and then apply for change of status back to F1 with the new I-20, or you just go outside USA for a new F1 visa stamping. Those are the 2 choices.
Okay.
Because while the B is pending, you don't have status. You just have authorized period of stay. You're allowed to stay.
Yeah, I am in the 60-day period right now, and B2 B2 is like submitted, but I have no communication. Like they received the documents for B2, and I want to know if I can go for F1. So you're saying it depends on the school whether they can roll the service or not, or is that?
Yeah, I think your international students office can tell you, your DSO can tell you what they can and cannot do with the service. Okay.
Okay.
And if they can just roll you over, then just withdraw your B2. You don't need it.
Is there a problem if I have a B2 and the F1? Considering that one can
there'll be a problem because if you get the F1 and then you are rolled over to B2, you change over to B2, now you have to get back onto F1. It's a problem.
Okay.
Okay?
Okay.
Good luck, sir.
Thank you.
You're welcome. Okay, let's go over to Illinois. Illinois, you have a question, follow-up question? Illinois? Area code 779.
Hi, Rajiv. Yeah.
Go ahead, sir.
I have a question for, the question was for the I-130 pending and the parents wants to visit USA.
Right, right, right.
So my question was like, in general, what is the ratio? Is it like 50-50 at the port of entry that they might be sent back, or it's like very rare chances they might be sent back? I mean,
you know, statistics are really not worth much in predicting individual cases. But I think it's better than 50-50 because, you know, these are people who have no reason to disobey the laws, violate US laws. I would certainly hope that any reasonable officer can see that and they should allow admission to such a person.
okay. And the next thing was, will it make any difference if they travel through Canada, like they take the Canadian visitor
No.
visa, go stay there for a couple of weeks?
The only advantage is if you have family in Canada, if they get turned back at the border, they can just go back to the family. So they don't have to travel back to India.
Okay.
All right?
All right. And the final question was, if I think to let them come here on visitor first and then apply for I-130, will they be allowed to get travel payroll while the I-130?
That's a very long, very long discussion. Go over the last three, four conferences that we've done. We've discussed this issue in great detail. If somebody enters USA with a tourist visa with a preconceived intention to convert to change status to green card, USCIS can consider that to be fraud. So be careful with that.
Okay.
All right?
Yeah. Thank you so much, Rajiv.
You're welcome. Good luck. Okay. Let's go to California. California, go ahead, please.
Rajiv, this is question number 16. So my follow-up question is, in the worst case, the USCIS makes a decision that they are not going to process my green card application under cross-chargeability rules,
Sure.
under the Nepal quota.
Sure.
Will they still be open to process my application in the India birth category?
They have no choice.
Or
They have no choice because unless they consider there is some kind of fraud or misrepresentation and make an affirmative finding, they have no choice. They have to take you under your country's quota. So if they decline to give you cross-chargeability, it does not mean they can take away your right to a green card. You'll still get it.
Okay. Fair enough. So at least I should make an effort. If it goes through, well and good. If it doesn't, at least my application will still continue for however long, and then it will get approved in a couple of years in the India category.
If I were you, not only would I fight it with USCIS, I would be prepared to go to court over it. Because the courts are much more likely to take it reasonably than USCIS is.
Oh, interesting. Okay.
All right.
Okay. So even if as long as there's justifiable basis for me to make this case and go to a court and make an appeal. Okay.
I think this is worth it. Yep.
Okay.
Good luck.
Okay. Thank you.
Oh, you're very welcome. Okay. All right. So there are no more follow-up questions. All right, folks. Anyone has any question, press *5, please. Anyone has any question, press *5. New, old, anything. 1, 2, 3, 4, 5. Okay, we've got 5 raised hands so far. Folks, please, 6. Make sure you raise your hand because these are the only 6 that I'll be answering, no more. Because we have to kind of husband our time. So make sure there are no more questions. 6 people, 6 set of questions. That's all we'll be doing. Very good. Let's get started. In the order that you folks called in. Texas? No, I'm sorry, Oregon. Oregon, go ahead, please.
Hi, this is P1S again. Um, uh, Regarding the answer you provided, should I leave the country and come back? And if that uh, um, scenario exists, then applying to F1 is it recommended?
I'm lost. You are the gentleman who is awaiting a tourist visa, doesn't have an I-20 in 60 days of F1. Are you the same person?
Yeah.
Okay. And
Yeah.
now,
Yeah, I want to get an F1 visa so that I can continue education. But since 60-day period is about to end, uh, if they ask me to leave the country and come back, uh, will I be able to enroll or no?
I do not know the answer to that question. It depends upon your history. It depends upon the officer who gives you the visa. There are too many variables. I can't really comment. I personally think your best bet is to convert back to student status within the United States. Okay?
Okay.
Good luck to you.
Okay, and I can do so even after the 60-day period because I applied to the B2.
No, I do not think so. Unless there is some latitude in service that allows them to roll you over. If there is if that is not possible, you'll have to wait until the B2 is approved, then apply to change of status back to F1.
Okay. Thank you.
You're welcome. Good luck. Okay. 5 more. Let's go to New Jersey. I was waiting for New Jersey. There's never been a call in which somebody from New Jersey did not call. Go ahead, New Jersey.
Hi Rajiv, this is Prem. Thanks for your service. Again, this is for the question number 14 regarding once my mother is on GC, once my brother is on F1, if she files on F2B category while on F1, can she file for AOS if my brother is inside US?
Yes. Only recommendation I would have is this: make sure that while the green card is going on, your brother does not travel outside USA. Let him stay here and wait until he either gets into H1B or gets his green card.
Look, I mean to say, F2B category it takes like for India 7 years.
I know that.
I
know that. If he travels outside, he may not get a student visa stamping.
Okay. So if she applies for AOS, he might get he's eligible for EAD, right?
He's definitely eligible for AOS when his priority date becomes current.
Oh, priority date has to be current.
He cannot apply for 485 or EAD until 7 years have gone by.
Okay. So even though he's in US on F1 visa or something?
Well, think about it. I mean, I'm sure you have seen this process. People get their I-140 approved, then they have to wait years and years before they can file 485. It is the same with I-130. I-130 and I-140 are very similar. I-130 gets approved, then you wait until priority date is current, then you file 485 and EAD.
Oh, okay, I got you.
All right?
Okay, then, what means when it is a current, then only he will be applying for I-485 and EAD. That's what.
Absolutely. Right. You got it.
Okay, thank you, Rajiv.
You're welcome. Good luck. Okay, so we've got, hey, where did 4 people come from? I thought, oh well. 4 more hands. Let's go on again to New Jersey. New Jersey, go ahead, please.
Hi, Rajiv. This is Kalpesh. I had consulted you in October 2013 for my mom's continuity of residency on her green card.
G.
She had one stay in India which was more than 6 months, like close to 7 months.
All right.
And when she came back, they had stamped the passport with ARC number, but she then made few trips, but all of them were less than like 6 months. But none of them they had stamped the ARC number.
Okay.
Is there any significance to the ARC numbers getting stamped when she came back after like 7 months?
I'll have to ask somebody in my office. I don't know off the top of my head.
Okay. The thing is, like last summer, she came in and within 1 month and 10 days, she had to go back because my sister husband passed away.
Oh no.
And after that, I had consulted you, and she came back in 2013, and then she's been staying here. Now, this end of this December is her 5 years from 2009 when she came.
Okay.
But in between, there is this 7-month-old stay in India. Like, is there can we go ahead and file for her naturalization?
Yes. The way it works is you can apply for naturalization 90 days before the 5th year, as long as she has actual physical presence in the United States of 2.5 years in the 5 years immediately before the application. Does she have 2.5 years of physical presence? 30 months?
Yeah, I think so. Yeah, because this has been she has 1.5 years.
Okay.
When she
Has
after
she?
9 months and
She's never
close
been.
to 1 year more than.
She's never been outside USA for 1 year at one go.
No.
Okay. And she has only one absence of more than 6 months, but less than 1 year.
So, less than 7 months. Yeah.
Only one.
More than 6 months, but close to 7 months.
Is that 7-month absence the time when she had the tragedy in the family, your sister losing her husband?
No. That was that 7-month absence was in 2010 and 11. The family thing happened last summer, and she came back slightly less than 6 months. She came back.
USCIS would always want to know why was she gone for more than 6 months. If there's a good reason for it, you should be all right.
Now, the reason is like she doesn't have a rent or anything right now. Like the reason, like she has to prove her domicile here, correct? Like she stays with me. She doesn't have any.
No, they still would want to know because their concern is: did you abandon the green card, or did you have any specific? For example, was she selling some real estate, or what exactly was she doing while she was gone for 7 months?
Mm-hmm.
Okay.
Okay, so any of those reasons, like a written reason, is good enough for them?
I would want a genuine reason. I don't want you to make anything up. Okay? Because remember, if we make a misrepresentation, we can be not only deported, we can be criminally prosecuted, and we will be barred from USA forever. So that's not something I would lightly advise you to even think of. Gotta be very, very meticulous about the truth. Just be careful. As long as you're telling the truth and there's a good reason for it, it's certainly worth going forward for the naturalization.
Okay. Now, what about this? There is another thing. Like if I wait, like there is a 5 year and 1 day. Like if you're more than country out of 1 year.
No, that's not for you. That's 4 year 1 day rule is for people who have a re-entry permit.
For re-entry permit, so she's not eligible for that. Correct?
Nope.
No, correct. So, say for in the worst case, if this 2011 when she came back, I take it as a reset of her residency, then I have to count 5 years from there.
I think that might be a better thing to do. Just wait until she's been back and that 7-month period is gone, and then do 5 years from that period. So that you can eliminate that 7 months from the 5 years.
Okay. And one more last follow-up question. She does have like a problem with her back also, and like she has been osteoporosis.
Right.
And she has a problem with the spinal cord. So there is this
disability N648, like, is she, needs to be, is she eligible just for say, or I have to go to a doctor and then...
it doesn't work. Nothing works with just your say. It has to be medically proven.
It has to be more. Okay, but she can go to a doctor of osteopathy and then
I do not know what kind of disabilities are allowed. I know for sure that people who have, for example, dementia have certain exceptions. How far does physical disability have to extend? How far it goes? What kind of benefits you get? Don't know off the top of my head. I'm sorry.
Okay.
All right.
All right.
Good luck.
Thank you.
Okay, we've got 3 more people. Let's go to California. Go ahead, please. California.
Rajiv, this is a follow-up question for question number 16. And I do not know if you may be familiar, but you may have seen such situations where people have to make a passport in India and the person was born outside of India. The passport rules in India require that the birth should have been registered at the time of birth in the consulate of the country where the person was born, the Indian consulate of the country where the person was born. But when that has not done, I'm known of cases where people had any alternative documents that were accepted in the Indian officer's passport office. I'm just asking because you might.
I have no idea. I have not practiced law in India for about 25 years. I have no idea. Okay, but I think you should get a lawyer. I don't think you should do this yourself. It's an important benefit, and if you do it right, you might end up not having to go to court over it. And so you can. I think you should get a lawyer. Let your lawyers take a look at the whole situation and present the evidence that they feel is best likely to convince USCIS. Okay, don't try to do it yourself. It'll be very difficult. Okay.
Right. Okay.
Good luck, sir.
Okay. Thank you.
You're very welcome. Okay, last 2 questions. Let's go to Texas. Texas, go ahead, please.
Hello. Good afternoon, Rajiv. This is Mayank Gupta. I appreciate your community service, and I'm highly thankful to you for this. So my question is, I'm here on B1 visa, and my I-94 is going to expire on December 26th, coming December 26th, and I have already filed an application with I-539 on 5th of December, like 20 days the expiration date.
Good.
So I wanted to know, can I stay here? I just inquired about the status. So they said that 2.5 months it will take. Mid-February I'll be getting a result of the application.
You are allowed to stay
here in you.
Yeah, Gupta ji, you are allowed to stay here. You are allowed to stay here while your application is being adjudicated. Don't stay beyond the time that you have asked for. So let's say you asked for 6 months. Don't stay here 7 months. If the application is still not adjudicated at the end of those 6 months, leave and make sure you carry proof that you had applied. Always carry that evidence because it might become relevant time and time again. Carry evidence that you had applied for an extension, your receipt, copy of your application, take them with you because consulates don't like extensions. And so does CBP. They can also create problems. But if you have proof that you applied for an extension for good reasons and you did apply in a timely manner, even if you don't get result by the time you leave, you will be okay. So to answer your question, can I stay while this is pending? Yes, you can.
Okay. And so one more thing, I am a medical doctor here in I'm back from India, and I have got an observership opportunity here. You must be knowing about the kind of an internship in a very famous hospital in US. So I have put that as a reason for my extension. Can you please comment on is this reason good enough that, like, what is the probability of me getting the extension on this reason?
It's difficult for me to say what the probability is, Doc, but it definitely is a very good reason. If you are getting an observatorship and it's in a very prestigious hospital, rare opportunity, I think a case should be made that they should give you an extension. It's a legitimate reason. You're not getting paid. You're not taking away an American job. So yeah, I think it's a good reason. Is it a reason good enough? That is highly subjective, Doc. It all depends upon the USCIS officer who is looking at the case. But if I were to make a guess, I would say it's a good case.
Mm-hmm. And sir, about the document thing, like I have submitted an invitation from the hospital, like which has the hospital which has asked me has given me an opportunity of internship. I have given the invitation from that. So is it enough, or do I need to submit any more documents, like kind of ID proof or something?
Well, Guptaji, the good thing is that USCIS, as long as you have followed instructions on submitting all the essential documentation that they require, if they want more information, they're not going to deny your case. They will send you a request for evidence, RFE, asking for more information.
Okay. Mm-hmm.
Okay.
Okay, so I'm good to stay here. Okay then. Thank you. I appreciate it. I appreciate your time.
You're welcome.
And your community service. Thank you.
You're welcome, sir. Good luck. Okay, so let's do the last question of the day, which is also from New Jersey. Here I was missing New Jersey. Go ahead, New Jersey.
Hi, Rajiv. I'm Shikha. I'm currently on H4 visa and will be applying for H1B change of status through an Indian consulting firm on 1st April 2015. So my concern is I have to immediately travel to India for my brother's wedding in April itself. The wedding is on 21st April. So is it a problem? Will my H1B COS be rejected, or what will be the situation like?
Shikhaji, the COS will be rejected, but not the H1. So when you come back, even if you get the H1 approval, you will have to apply for either change of status back to H1 again, or go for visa stamping, H1 visa stamping.
So will the change in status on coming back, and will it be like a fresh process, and I'll have to do it in next April, or can I do it anytime?
No. Oh, you can do it anytime. The only problem is a change of status back to H1 in terms of government scrutiny and inquiry is almost like doing an H1 again. You are not subject to the quota, but they are going to look at the whole case all over again. That's all.
And how much time does it normally take?
You can file premium processing.
Okay, so I can go for premium processing. And is there an option to get my I-94 updated once I'm back in April itself?
No, ji. I-94 updation simply means change of status.
Okay. Thanks a lot.
You're welcome. Good luck.
Thanks. Bye.
Bye-bye. All right, folks. As always, I am very, very grateful that you folks are all here, and we spoke. And again, in a couple of weeks, next Thursday, we'll talk again. And good talking with all of you. Thank you. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.